computer. That's what I do. Good morning, everybody. Welcome to Next Gen on day 91. We have the fabulous Miss Cindy Flynn speaking to us about labor law. There are many reasons I find Cindy quite interesting. First of all, she's one of the greatest marketers I know, and I just love being a marketer myself. I love watching how she works, and I've told her that before, so I think she knows that. But also, she is passionate about what she does because she grew up in a family business, as I, and saw what happens to small businesses when they don't have good guidance and representation. And she decided to become a labor lawyer. And she's become very good at being a labor lawyer and helping small businesses kind of get through the morass of what the state of California and the federal government does. And in these great times, I think she probably does 8 Zoom meetings a day, talking to people on this very topic. And so, Cindy, you've got about 20 minutes to tell us what's going on, and then hopefully there'll be some questions for you. So are you ready to take it away? And here she is.
Yes, I am. Okay, thank you, Tom, so much for having me. I'm happy to take questions throughout. I'm just going to share my screen so we can go through this. If anyone has any questions, obviously it's a pretty small group, so just speak up, or you can always put it through the chat as well. So Tom, thanks so much for having me come speak. I think I've spoken to your group before, so it's a pleasure to be back. And I wanted to go over, what it's going to be like as we start to reopen our businesses after COVID-19. And so here are just some best approaches. From an employment lawyer's perspective, I think we're going to see a rise in the next 6 to 12 months with employment lawsuits. And so it's really important to do everything we can now to protect ourselves, our clients, our business owners, our friends, all who are trying to do everything right, and things have changed so fast. So with that being said, I wanted to start out with a disclaimer because I am an attorney that content on this webinar should not be considered legal advice and is for informational purposes only. Communications made through this webinar and or participating in it do not create an attorney-client relationship, although of course I'm so happy to create one with you afterwards. In addition, we're not responsible for any content you may access through third-party resources. So a couple things about today. I have some updates on the PPP program, the expansion of unemployment benefits, how we can safely bring back the workforce, and then just working remotely and having your staff do things correct when you have them work from home. So as the coronavirus outbreak continues to impact markets and industries all around the United States and truly all around the world, businesses have been confronted with some very unique, significant challenges, right? And we are doing everything we can to stay on top of it. So the CARES Act, was originally signed into law on March 27th. It has then been expanded. It originally provided for the $2.2 trillion stimulus. And today I just wanted to focus on 2 quick things, the PPP program with some updates and then unemployment. So the PPP program, I hope we've all applied for it by now if you think you're eligible. I just heard this morning, though, that if you haven't applied yet, there's still $100 billion in loans left as of today. And I'm happy to put you in contact with a banker who can help. And that really goes for, my network is just as big as Tom's. So if anyone needs a referral source to any professional service company or firm, I'm always happy to pass on along referrals. So the covered period, is from February 15th to June 30th. And it was originally funded with $350 billion on April 24th, and then of course another $310 billion in loans shortly thereafter. And we have to remember the purpose of this loan program allows businesses suffering due to the coronavirus outbreak to borrow money for a variety of qualified costs related to employee compensation. And keep in mind, the SBA on a normal year does 62,000 applications. In the last 8 weeks, they've done 5 million. So they are extraordinarily busy. And a couple things that I've heard recently, two things that I wanted to share with you. They are talking about extending that 8-week from the day of funding. So essentially, I'll get to this in another slide, but just to update everyone quickly, you know, you have 8 weeks essentially to spend all the money in order to seek loan forgiveness, right? They're talking about extending that period from 8 weeks to 12 weeks for everyone. And the SBA doesn't want to take this money back or provide loans. They actually want to see everyone get loan forgiveness. So I think that they're going to try to continue discussions and see what they can do that actually really helps business owners. The other thing I wanted to note here is that if you are a business that was closed and received the funding, like a lot of restaurants, they have yet to be reopened, some of them, and you know that 8-week period is supposed to start on the day of funding. They are in talks about extending that to the date when the business reopens to start the 8-week period. So if you know of businesses who, you know, might have gotten the PPP funding and then they're dealing with, well, do I bring everyone back to just sit there because we can't necessarily reopen? There's been discussion about that. So anyways, the qualified costs, I'm sure we all kind of know this by now. It's been out there for a couple of weeks, but it includes payroll costs, and these are defined as wages, commissions, salary, or similar compensation to an employee. It also, interestingly enough, includes allowance for a dismissal or separation from your employee. So essentially, you can give someone severance under this, is how I'm reading it. This includes payment for group health care benefits, for those premiums. It includes payment of any retirement benefits, payment of state and local taxes assessed on the compensation of employees. What this excludes, though, is any employee whose compensation is over $100,000 annually. So there's that cap. I should note off the top of my head, but I think it's like $13,569, but don't quote me on that, on where each employee maxes out as far as employee compensation. But then you also get the healthcare benefits on top of that. In addition to payroll costs, you know, it includes your mortgage interest obligations, your rent, your utilities, interest on debt incurred. And remember, like, this is based on the gross pay to the employee. So the idea is that anything that's included in your employee's paycheck stub is included under what would be considered a qualified cost on your PPP program. And that includes reimbursement, as long as you were reimbursing them prior to February 15th of 2020, reimbursement for cell phone and internet if you have those workers working remotely, or just reimburse them for another reason. So eligibility, you know, if you're a small business that employs 500 employees or less, or if your business is in an industry that has an employee-based size standard through SBA that is higher than 500 employees, then you qualify. And, you know, we're getting a lot of questions. Well, how did Chick-fil-A, how did the Lakers, how did Ruth Chris, how did Shake Shack get funding? Well, there is, you know, a specific section in the code section that allows them, but as we've heard, a lot of businesses are giving that back. And so you had to have also been operational as of February 15th and then have employees. So the loan is limited to either $10 million or 2.5 times the sum of the average monthly payroll cost. And it's really intended to cover 8 weeks of payroll expenses and any additional amounts for making payments towards debt obligations. So it's an 8-week period that may be applied to any time frame between February 15th and June 30th. And mind you, if you do not get loan forgiveness for whatever reason, the interest rate on this loan is at a maximum of 1%. So we're seeing a lot of 0.96%, 0.98%. There's no prepayment penalties or fees associated with this loan, which is incredible. So in the event that you're not able to get everything forgiven, it's still a great loan. Payments are deferred for 6 months, but interest will accrue. And so loans may be eligible for loan forgiveness on a tax-free basis, and an eligible borrower of a covered loan period under the SBA can get forgiveness related to payroll costs, interest on mortgages, covered rent payments, covered utility payments, and that's starting at the 8 weeks from when the SBA loan was originated, when you got that funding. What else do I want to say about this? A common question we've been getting is whether or not you can prepay rent. The answer is no. It is just for rent during that 8-week period. But whatever you're doing and whatever calculations you're running, make sure you are running it by your CPA and your banker. Another common question we're getting is if you can prepay your employees. Please do not do that. You cannot do that. Don't do that. Please don't do that. But here are some other things that you may want to consider. So as another question we're getting on like prepayment to employees or payment to employees is whether or not you can bonus them out. Now, I don't think that a bonus to your employees will be covered unless you historically have always given your employees bonuses in May, or they're non-discretionary bonuses, something that you can relate back to over the last couple of years of this is how we do it. But that being said, you know, some businesses are doing hazard pay bonuses. Now, in general, we don't really recommend hazard pay. I just read an article this morning about how Amazon is eliminating hazard pay moving forward. And of course, employees are upset because once you give employees like an extra bump in pay, $1, $2, $3 an hour, it's very hard to take that away. And so from a business owner perspective, we don't necessarily recommend it in this type of circumstance because there's no set time on when this pandemic is going to end, right? Like there's no, like we're not at war and then the day war ends, there's a specific day. So we don't typically recommend that. That being said, we have seen some companies who are open and having people, you know, have contact with the general public or whatever it is, you know, pay bonuses out as a hazard pay bonus. I'm not 100% sold that it will be forgiven, but that might be one option you want to consider. And if you're okay giving that sort of hazard pay bonus out to your employees with the off chance it doesn't get forgiven, you know, you can make that decision as a business owner. A couple other things, you know, the whole purpose of the PPP program is to help you retain your employees at their current base pay. So if you keep all of your employees, the entirety of the loan should be forgiven. If you lay off your employees, the forgiveness will be reduced by the percent decrease in the number of employees. So if your total payroll expenses on workers making less than $100,000 annually decreases by more than 25%, loan forgiveness will be reduced by that same amount. And if you've already laid off some of your employees, you can still be forgiven for the full amount of your payroll costs if you rehire them by June 30th of 2020. What does rehiring look like? You need to do a written offer letter back to that same employee that you laid off. And mind you, it has to be, or we would recommend, I think it does have to be the same rate of pay, same hours worked. And the purpose of that provision is to really encourage the employers to rehire any employees who have been laid off due to the crisis. And as a borrower, if you rehire workers, you will not be penalized for having a reduced payroll. And in updated guidance from the SBA, it was clarified that if an employee who has been furloughed or laid off is offered rehire and declines, that employee may be omitted from the loan forgiveness reduction calculation. However, make sure it's just documented. And one more thing I want to mention about the PPP program is that if you get funding, you know, May 1st or whatever it is, and it goes 8 weeks, and depending on your payroll cycle, you might want to consider running an extra payroll at the end of the paycheck period if it doesn't fall on the exact date of when your last covered payroll period is. So I think that would be completely fine. But again, just make sure you're keeping your banker and your CPA apprised of what you're doing. Now, what's going to be required for seeking this loan forgiveness is documentation. I mean, everything just needs to be documented. Your offer letters out, your number of employees, your pay rates, those types of things. An easy way to think about the June 30th, 2020 deadline about rehiring is that if you have an employee who is claiming unemployment as of June 30th, you are going to be penalized. If you don't, then you'll be fine. Most likely.
Question.
Yeah, Tom, go ahead.
I heard it, and again, I think if this isn't the right place to ask it, just let me know. Someone asked yesterday, it was a law firm, that they want to get their employees to come back into the office. As openings happen, can they legally ask people to come back in, or is it to the employee's discretion of when they think it's safe to come back in? I mean, how is that going to look, do you think? No,
I mean, look, business owners can absolutely require their employees to come back to work. There's nothing that says, an employee who can work from home can stay at home and have the option. So the only time that there's an exception to that rule is if there is an imminent danger or harm in the office building. So for instance, the law firm wants to have all of their employees back under one roof for whatever reason. I don't know why you would want to do that. I think maintaining social distancing for as long as possible is a good thing. But if you need people back in the office and they are not following CDC protocols, they're not wiping down countertops, they're not wearing masks, they're not doing the things in order to be safe, they are having employees with COVID come in sick. That would be a reason why an employee can actually choose to not come back into work. But the threshold question is whether or not there's an imminent danger at the office where somebody could get sick and die. That's the bottom line. Okay, so just real quick yeah, please.
Pardon me, I've got a question with regards to the PPP. So a lot of employers are kind of operating, let's say maybe a third of their staff or 2/3 of their staff, maybe half, but definitely a reduced employee force. How does the payroll protection program respond to only part of the people coming back? Is there any kind of thing that employers should be looking out for when they only have part of their staff coming back?
Yeah, their forgiveness is going to be reduced. So they're not going to get full forgiveness. Yeah.
Okay. So
yeah,
if you can't operate completely, but you can operate partially, let's say you're still essential, but you're not a repair shop. No one's driving their cars right now. So maybe you've got a third of your regular business. But you got the PPP for the full boat of your payroll. Can you explain kind of how that works?
Yeah, so the business owner has the choice between paying everyone, right, as they were previously making before and just giving that money out, whether or not they're working. I mean, they can still have the person come in and just sit there or have them sit at home. Or they can, take that money, let's say it's $100,000 that they got with the PPP loan, and they're only going to be using $50,000 for payroll in order to keep employees working who actually have work. And then the other $50,000, I mean, take that as a 1% loan is what I would recommend from a business perspective. That's not going to be the right decision though for everyone. And some people may want to just have it all go to their employees, which is totally fine. I mean, that's well within that realm. But every business has to make their own decision there.
So regardless of whether or not you're open, if you pay that money to the employees, it's forgiven.
Yeah.
Okay.
Yeah.
Thank you.
But you want to be careful that you're not just increasing everyone's rates for no reason and having them sit at home, or paying them out these weird bonuses that don't make any sense. Like that, I think you're going to have problems with. You can't take all of your staff. Well, I wouldn't recommend taking all of your staff who are minimum wage workers at that automobile repair company, raising them all to $100,000 a year for an 8-week period, and then reducing it back down. I think that's where people are going to have issues, and that's when audits are going to happen. And the SBA has said any PPP that is over $2 million will be audited.
Got it.
So,
thank you.
yes. Tom, you tell me when to stop. You're muted, Tom. Keep going.
Point. Everybody should
Okay.
keep going. Thumbs up to keep going. Thumbs down to keep going. Okay, here the thumbs are up. Keep going.
Okay, perfect. Just stop me anytime. Okay, so with the unemployment insurance benefits, you know, part of the CARES program is expanding uninsurance benefits, and this allows for individuals who were furloughed or out of work, whether temporary or permanent, get unemployment, right? And it, as of April 28th, it finally opened. They announced it a long time ago, but self-employment or gig workers can now get unemployment. And I know people who applied that first day on April 28th are finally getting it in the mail as of yesterday. So it took them a couple weeks to get everything together, but you should start seeing those self-employed or gig workers who need unemployment start to get it. Now, with unemployment, the federal government increased the benefits, right? So it's an extra $600 a week for up to 4 months through the end of July. Last I've heard, they're talking about extending that until January 2021. And so in California, if you receive $1 in unemployment benefits from the state of California, you are qualified for that $600 additional unemployment benefits from the federal government. Now, the extra funds may be paid as a separate check or together with the traditional unemployment check that's provided by the state, but recipients who were previously nearing the end of their unemployment can apply for a 13-week extension. And in California, the total benefit extends for 39 weeks. That's how long it took me to grow a baby and give birth, exactly 39 weeks. So that's 9 months, which I thought was interesting for the unemployment benefits. A common question and a thing we've been having to talk through with a lot of our clients who, of course, are business owners, are what if we have employees who we had to lay off in March, they are receiving this unemployment, and now they're receiving more unemployment than what we were paying them, right? Like that's a very valid concern. And how we're telling our clients to couch this with their employees is to say, you know, unemployment is only for a short period of time, right? We are offering you work right now, and if you are choosing actively not to come to work, that's fine, but you're gonna lose your unemployment benefits because you don't have the opportunity to just sit at home. And you can pause your unemployment benefits for that period of time where you bring them back to work. So if things change July 1st, after second quarter earnings come out, or you know, we see a big crash in some area of our economy, you know, they may need that time, that 39 weeks at the end, you know, later on in the year. So that's kind of how we're telling our clients. So I'm not going to spend too much time going over OSHA. Read the website if you want some good reading right before you go to bed to help you sleep tonight. OSHA has come out with more regulations in the last week, another 37, 39 pages. But basically, there are guidelines on OSHA that identify employee risk categories. And this is to assist employers in determining what safety precautions are necessary. We don't have time to go over it in complete detail because it's so long, but basically OSHA puts you into high, medium, or low risk categories. And those high risk categories are healthcare workers, healthcare support, medium are the school staff, those working in high volume retail, those working in high population density workplaces, and then low are those office workers, remote workers, and as we bring back the workforce, you want to assess the risk and determine next steps with employees who are returning from affected areas, those in close contact with those returning from affected areas. Those, of course, are not too big of a concern, more along the lines of testing positive for COVID-19 and showing signs and symptoms. And we put together a COVID-19 plan in place because it's probably not a matter of if an employee tests positive for COVID-19, it's a matter of when. And I'm happy to send that to anyone who emails me. It's a couple pages, and it talks about how you can put your task force together and what to do if somebody tests positive. So I'm happy to send that to anyone who wants it. Just email me. My email address is at the bottom of every single slide, thanks to Tom's brilliant recommendation like a year or two ago. And so employees returning from affected areas, they're required to self-quarantine, mandatory health screenings by federal, state, and local authorities. And then CDC has guidance there. Same with employees who are in close contact with others from returning from affected areas, similar thinking. But what I wanted to get into is, what do you do when an employee tests positive for COVID-19? And really, it is to immediately send them home or have them remain at home, immediately treat the affected areas in which the employee worked. The CDC has specific recommendations there. Advise employees and or customers who were in contact with the affected employee, offer them reimbursement for medical testing, file workers' compensation paperwork. Yes, we will get there. Contact CDC. And then it's really important not to identify the employee by name. Anyone who's showing signs or symptoms, you can send the employee home upon the observation of symptoms consistent with COVID-19. Follow CDC guidance for release to return to work for these employees. Immediately treat the affected areas pursuant to CDC, and advise customers and employees who were in close contact with the employee sorry. Some distraction there. Do not identify the employee by name. You can say that there's been no diagnosis, but that you're acting in an abundance of caution. Jeff, do you have a question?
Yeah, Cindy, on this stuff, so is there a sunset or an end to these regulations? As they talk about COVID, you brought up not if, but when. So let's say this happens a year from now, that we've got someone testing positive for COVID. Is there anything that you've seen that says how long we need to adhere to these regulations?
I don't think so. I haven't seen like, oh, this is going to end. I imagine when the stay-at-home orders start to be lifted, yeah. And how things, continue to unveil.
I haven't either.
Yeah.
Okay. Yeah.
Yeah.
Thank you.
And then just so you know, in order to assess the risk, you may ask employees to inform you if they have encountered someone who has been diagnosed with COVID-19. You can ask them to inform you if they have symptoms of the virus or they themselves have been diagnosed. And then, of course, any recent travel to affected areas. What you may not do is target individuals, employees, unless you have an objective basis for asking. So when all of this was coming down, we had some business owners tell all of their staff over the age of 65 to go home, that they weren't needed at work, and that is age discrimination. So you need to observe an objective basis for asking. You can't just send older people home for that. And, our clients have the best intentions, but sometimes, you're acting so quickly that you don't realize that you're asking for an age discrimination lawsuit there. And then you also do not want to ask about any other underlying medical disability or medical condition or any information in that regard. Safety precautions, here's the CDC's website. Bottom line is that, you need to ensure that all frequently touched surfaces are cleaned and disinfected regularly throughout the day. That means your tables, your doorknobs, your light switches, your countertops, your desks, your phones, your keyboards, faucets, sinks, toilets, all of those types of things. You really want to err on the side of precaution when assessing risks. The CDC has a whole risk assessment guide on their website, and so follow that. And then this is more in Jeff's wheelhouse, bringing back the workforce. On May 6th, California Governor Gavin Newsom issued an executive order creating a temporary workers' compensation presumption for employees who have been diagnosed with COVID-19. This presumption is retroactive to the date of the stay-at-home order and will stay in effect for 60 days after its effective date. So the presumption, and this, Jeff has a specific time frame. It's effective for employees working from March 19th, 2020 through July 5th, 2020. And so under the executive order, any COVID-19 related illness shall be presumed to arise out of and in the course of employment for purposes of awarding workers' compensation benefits if these couple things are met. So the employee had to have tested positive for or diagnosed with COVID-19 within 14 days after a day that the employee worked for the employer. The day on which the employee performed work at the employer's place of business was at the discretion of the employer, was after March 19th, right? It has to be between March 19th and July 5th. And it has to be at the employer's place of employment. So it's not the employee's home. So if you have workers working remotely, they do not qualify unless you make them go in. And then the diagnosis must be done by a physician in California. And the presumption covers any employees who must work outside of their home during the stay-at-home order at the employer's discretion. So this presumption is rebuttable. It may be controverted by other evidence, but it's gonna be interesting to see how it plays out. And again, if you have employees working from home, they're not covered. OSHA, to the question earlier about whether or not an employee can refuse to come to work or whether or not you can make your employees come back, the answer is yes, definitely, but the employee may refuse to come to work if they believe that they are in imminent danger. And there's a specific definition to imminent danger. It has to be reasonably expected to cause death or serious harm, physical harm. So unless you're putting your employees at risk in that sense, you can have them come back. For anyone who is having an employee work remotely, I think it's really important to have a work from home agreement. You can outline that this is just temporary while the California stay-at-home order is in effect or whatever else. I did hear something the other day that 25% of people who are now able to work from home are going to continue to work from home even after things go back to normal, which is going to save on traffic for anyone who commutes. And I think it's important to really lay out those job expectations, a start time, an end time, being available and responsive throughout the day, following company procedures. And make sure these last two things are very, very, very important. You have to have the ability to track time worked. Now, it doesn't have to be something fancy. It can be a simple Excel spreadsheet. I clocked in at 8. I took my break at 10. 10 to 10:10. I clocked out for lunch at noon. Just something that says you are tracking an employee's meal and rest periods, because we all know what's going to happen in 6 to 12 months. The employee, and mind you, I saw it yesterday. I haven't been able to take a lunch. I'm too busy. Well, guess what? You need to pay them for that missed meal period, and you need to write them up for it, because you absolutely need to keep track of this. I can't stress this enough. And then the other thing that I don't think a lot of business owners are doing when you have employees working remotely is reimbursing them for expenses such as internet and cell phone. an employer cannot pass along operating expenses to an employee. And even if the employee already has cell phone, even if they already have internet at home, the business cannot get a windfall, right? There is case law that says that. So please be reimbursing your employees for expenses such as internet and cell phone. There's no specific amount. It doesn't have to be like 100% or $100 or $200 or whatever it is. It just needs to be something that's reasonable. So for cell phone reimbursement, you know, do $50, just something, you know, something based on, yeah.
Real quick, what is employee determined as any employee? If you're an employee, period, you have to clock these things in. So if I'm an employee of a law firm, I'm an employee of, you know, where I'm a high paid individual, is that an employee? Or I'm an executive at a company? Is that, do I have to clock in lunch, clock out lunch and all that sort of thing?
Oh, sorry. I was referring there on non-exempt people.
Okay.
So anybody who's hourly or anybody making under $50,000 a year salary, you want to track their time worked. I should have clarified, Tom. Thank you. Yeah. If, you know, yeah. So. Good question. And then, you know, really, no matter who your employment attorney is, please make sure before you do anything this time of year in the pandemic, check in with them. At the very least, you should be checking in with them a couple times a year, one for a handbook review. I'm happy to send out to anyone who wants it a whole playbook on how to reopen your business. And part of that playbook, at the end of it, I have an employee addendum that you can simply just add to your current employee handbook. I also have a welcome back letter. As our businesses are reopening, you know, you may want to send your employees a letter kind of explaining that. That's included in that playbook. Anyone can email me for that. I'm happy to send it out. Also make sure that whoever you're using as an employment attorney has an experienced team of attorneys behind them. All of the attorneys who work for me have 12 to 20 years of experience. They know employment law inside and out. And you don't want to be passed off to a first year, you know, law student. Also, what we do very early on is a liability assessment, right? Because oftentimes, you know who's going to sue you. You see a red flag come up, you see another one come up, and you want to ignore it. It's so much harder to fire that person and find someone new. Those are the people who tend to sue you. We've had clients who are sued by the best man at their wedding. We've had clients who are sued by somebody who's worked for them for 25 years. And so doing a liability assessment early on allows the business owner, I think, to make a decision. You know, do we offer severance and let this person go, or are we going to take this to trial in the event that we're sued? So here's an employment compliance checklist. I'm also happy to send this to anyone who wants it. It's basically 19 things that you want to keep track of, make sure that you're doing to maintain your employment law in California is compliant. And then you can either text HF Law to 66866, and I can automatically send you that checklist. And also, if you want to get on our mailing list, you know, I do not spam anyone, but I think it's so important to get information out there as quickly as possible to our clients, our friends, just anyone who's interested as a business owner. One of the things that was updated most recently was the Department of Labor sent out a new poster that you need to post for your employees. So I sent everyone on my list, here's the link to the poster, download it, email it to anyone who's working remotely. That way you're just staying up to date. And I'm happy to answer any questions you have at this point, and there's all of our contact information.
Any questions out there? Raise your hand. Well, I have a question. Oh wait, Jim has a question. All right, Jim, take it away.
Yeah, that was a great overview. Thank you, Cindy, so much. Back on the hazard pay issue, because I was thinking, because you know everyone's working very hard at Arroyo. Do you have to? Would it be? Well, it sounds like it's up for discussion whether or not they're going to allow it. But if you sent a letter to your employees along with their payroll indicating a descriptive thank you for your extra work working from home, and you know, would that make things better, or would it qualify to have something in writing to go along with any bonus pay if you were to do that? That would be my question.
Well, if you have employees working from home, they're not in a hazard. So I probably wouldn't recommend you giving out a hazard pay bonus to anyone who's working remotely. And as of right now, there's very little guidance on whether or not COVID-19 constitutes a hazard under OSHA standards. I mean, things are changing daily. I recommend employers follow all OSHA required standards. You know, there's, you can follow the aerosol transmissible diseases standard, which is aimed at preventing worker illness from infectious diseases, which include bacteria, COVID, things like that. But if you are giving out a bonus, I think, you know, there's a chance under the PPP, of course, that it's not going to be forgiven. But in the event that it is, I think it would be okay to say that, you know, we recognize you for going into the office, and here's a hazard pay bonus. I think that might be a good way to go.
Jerry?
Is there another question?
Jerry, did I see a question? Yeah.
Yeah, Cindy, you'd mentioned something about the, in regards to the payroll forgiveness plan there. Somebody that was making over 100,000 a year. Is that, are they disqualified, or is it just up to the 100,000?
It's capped at 100.
Okay.
So yeah, so if someone's making 120, you know, you would only do based on 100, and then you divide it by like that 8-week period to get that number, like 13,500.
Okay, thank you.
Any other questions? So I have a quick question, and that is, if you put on your crystal ball and say COVID, you know, 2 years, we have a vaccine, it goes, you know, COVID-19 goes away, how is this going to affect labor law in the future, do you think? What do you think? Is there going to be a lasting effect from, there must be, but if you were going to have a crystal ball, what would you guess the changes will be?
So I think we are going to see a huge rise in we are seeing a huge rise in unemployment, but I think we're going to see a huge rise in employment lawsuits. As workers are laid off, they get desperate. You know, we just see it with any economic downturn. And as that begins to happen, I mean, we had, Tom, 5 clients come to us within a week of, all at the same time, because they had terminated somebody in February or March, and, you know, they're claiming that they were wrongfully terminated, and that they now want to sue their employer. I had clients with letters within 24 hours of being let go from someone, get a demand letter from an attorney saying that it was a wrongful discharge. And so I think that it's going to continue to rise. And it's going to become an employer's market. I mean, employers can be very picky about who they hire, but when thinking about firing, you want to make sure all of your I's are dotted, all of your T's are crossed. And I think we need to accept this as the new normal for quite some time. This is just how it is. You know, California is now, I just heard the other day that Wisconsin Supreme Court ruled that the stay-at-home order was unconstitutional. So we're going to see a lot of litigation, but in California, you know, we haven't seen anything like that, and all the courts are closed right now, and, you know, things are not going to get back to normal for a while. So
Do you think that and this is probably a dumb question, but will the legislature do anything to help small businesses in terms of some sort of protection about all the lawsuits, or do you think it's just going to be a free-for-all? Yeah.
Yeah, I think it's just going to be a free-for-all. I mean, you can't, that would be unconstitutional, right, to prohibit somebody from suing somebody. So.
Yeah, no, but I mean, it's unconstitutional, but they could, I mean, at some point said that a human life was worth $250,000 or some number like that, right? So, I mean, they could do
That's
some sort
true.
of tapping or something, you know? So,
Yeah.
all right.
I
All right.
No.
Any other questions today? Well, I appreciate everyone coming to this. I have a quick poll, and that is, I always like to know what people might like to hear next. I've got some ideas of what I'm going to do, but I would love to hear if anybody has any thoughts. Or real quick, I'm thinking about doing a whole series of things on what does pivoting mean, and look at it from an operational, communication, marketing. I think the nice thing about if there's a nice thing about what's going on right now, is it gives you a chance to think about what's working and not working in your business and make some adjustments. So, what's the thought process behind making those adjustments? So that's one of the things we're thinking about. All right, 5, 4,
I would
3.
like to ask a question.
All right, go for it.
How many of you, if you don't mind sharing, were able to secure a PPP? Yeah. Okay. Thank you.
And just so everyone knows, if you have anyone interested to hear me again, Jeff and I are doing a live Q&A on Tuesday with more changes that are coming out at 11:30 a.m. So if you have anyone in your office that was not able to make today, Jeff and I are doing a live webinar then.
Okay, we've got a couple people I've never met before. Before you go, Derek, tell us what you do, and Carrie, tell us what you do, if you guys don't mind listening. So quick, what do you do? And
yeah, absolutely. Thanks for having me. And Cindy, I've got just a quick question for you as well. I'm an agent with New York Life Insurance Company. So if I've got a colleague who exhausted their UI benefit last year, and when they go online, it only lets them go to a particular point. And the numbers they call, they're all pre-recorded messages. So is there any number to call to get a hold of an actual live human being to talk about overriding that, the fact that they've exhausted their benefit and given the circumstance that they're in now due to COVID?
I don't know if there's an actual phone number. I know that EDD has been completely swamped and overwhelmed. I would suggest them just reapplying on EDD, and then they'll get a notice in the mail, because it should be extended for an additional 13 weeks for anyone who's already exhausted their unemployment benefits. And we are seeing clients who are not clients of ours, but like employees who have been let go, start to get that. So they should be hearing something in the next couple of weeks, I would imagine. I hope that helps.
great. Carrie, tell us about yourself.
Hi, I am Carrie Spell. I am co-owner of the production company Concurrent Productions, and I make marketing videos.
Very cool. All right. Well, thanks for joining us.
Thanks so much.
All right. Thank you, everybody, for coming. And again, we'll do another one next week. So have a great weekend and enjoy life. As usual, Cindy, you're fabulous. Thank you.
Thank you, Cindy. Thank you, Tom. Bye, everyone.
Hi, Jeff. Thank you, Cynthia, and thanks, Tom, for putting this thing together.
You bet.